Mr. Holtman, you may present your argument.
Thank you, Mr. Chief Justice, and may it please the court. We're here today, as you know from reading our briefs, we believe the overarching issue with respect to this appeal has to do with whether or not the plaintiffs had standing. It seems to us that this is was, in essence, a lawsuit in search of plaintiffs, and unfortunately for Mr. Warnock, he selected the wrong plaintiffs. In reading the briefs, you can tell that these plaintiffs never had any of these alleged prohibited provisions enforced against them. They're not out any out-of-pocket costs. They don't even know what provisions perhaps are prohibited. Two of the named plaintiffs did not even read the petition before it was filed. Some of the plaintiffs met Mr. Warnock for the first time at the deposition. I mean, what we have here is Mr. Warnock, on behalf of his tenants' organization, trying to get a ruling from a court as to whether or not these various lease provisions are prohibited or not.
The concern I have, Mr. Holtman, with your standing argument is it's based on federal law derived from Article 3 of the Constitution, the case or controversy language. And, for example, in Spokio, which I don't know if I'm pronouncing it right, that's a case based on Article 3. We don't have that counterpart necessarily, do we, in Iowa? And why should we apply federal constitutional standing law if we conclude that, and I agree that's an if question, if we conclude the legislature intended to authorize a recovery in this instance?
Well, but I think it's our position, Your Honor, that Iowa has, in the Alon's case and in the Sanchez cases, in essence, adopted the federal jurisprudence with respect to standing.
Those are nonetheless, all of the ones I could find were all cases against the government. And here it's one private party against another, right?
Well, that's right. It's one private party against another. There's no question about that. But I still would submit to you that this court has held in your prior cases that at a minimum there has to be actual imminent harm with respect to standing. And whether you say that derives from the federal cases or not, that's the fact.
But counsel, that it strikes me that what's going on here is essentially, at least in significant part, a declaratory judgment action. And isn't it just routine that parties in declaratory judgment actions come to the court and say, Judge, tell us what this provision means, before any party is damaged and before they've suffered any harm? Isn't that really what's going on here? And doesn't that sort of tell us that maybe the standing analysis doesn't quite fit?
Well, Your Honor, at the time this lawsuit was filed, none of these plaintiffs were under the lease that's at issue. The one plaintiff no longer even lived in the unit. This is at the time the lawsuit was filed. And it seems to me that with respect to a declaratory judgment, there still has to be an underlying dispute between the parties. My client didn't even know who the plaintiffs were in this case until the lawsuit was filed. There was never an instance where there was communication or correspondence between my client and these named plaintiffs about a lease provision, and is this enforceable or is this not enforceable? Was there a door that was damaged and who's going to pay for it? Was there a key that was lost?
We find that you don't have to have actual damages and you just get liquidated damages. There is an injury by making them sign a lease that signed away some rights that you can't sign away.
Well, that's correct, Your Honor, and that's the Staley versus Barkalow decision, which we think was wrongly decided, because just the mere signing of the lease, it doesn't comply with the statute. They are arguing that the statute confers the necessary harm upon them, which gives them the right to come into a court of law and sue somebody, sue the landlord. So you have to look at the statute. You have to look at the structure of the statute to determine, is that the harm that's set forth? And the Barkalow court, our Court of Appeals, said yes, the mere signing of a lease that has a prohibited provision in it, we're saying that that constitutes sufficient harm to bring a lawsuit. And we disagree with that. We do not believe you can read this statute and come to that conclusion. The whole structure of the statute is based upon enforceability. It doesn't say a provision prohibited by Section 1 included in a rental agreement is void. It doesn't say void.
But can't you read the statute as well to infer that the legislature was trying to ensure that landlords in Iowa would not use these unenforceable provisions in a lease for the fear that unwittingly tenants wouldn't know about their remedies and wouldn't know that they were unenforceable, and then they would comply with them? And if that's the case, who else is going to enforce these provisions other than the tenants that have them in their leases?
Well, Chief Justice, it's our position that if you read the statute, it only, there has to be enforcement of some type, which then triggers whether or not a certain provision is prohibited or not. That's the structure of the statute.
Let me ask you a question. In Oregon, and it always frustrates me when we don't adopt uniform laws or we adopt homebrewed versions of uniform laws. But in Oregon, the statute says if a landlord deliberately uses a rental agreement containing provisions known by the landlord to be prohibited and attempts to enforce such provisions, the tenant may recover. We opted for if a landlord willfully uses a rental agreement containing provisions known by the landlord to be prohibited, a tenant may recover. Doesn't that suggest that mere inclusion of prohibited provisions without enforcing them is sufficient in Iowa, at least under this statute?
Well, where we disagree then, Your Honor, is if you read the whole provision, it talks about recovering, you may recover actual damages. The only way you can recover actual damages is to have an enforcement. The mere inclusion of a prohibited lease term is not going to, there are simply no actual damages, just as these plaintiffs testified in their deposition. I mean, they have no idea what this lawsuit is about. They're not out any money.
Well, counsel, maybe I misunderstand your point, but I'm not sure I agree with what you just said. To the extent that a tenant executes a lease and pays fees which are prohibited by the statute, doesn't that tenant incur actual damage even though the landlord hasn't sued on the lease and attempted to enforce the bad provision?
Well, I don't think it does in the context of the way this statute is written. As I said, Your Honor, I believe it's an enforcement statute. It's not, you cannot read this any other way. It's not a mere inclusion type statute.
Well, Counsel, does the Section 11, when it says uses a rental agreement containing provisions known, et cetera, does use, to use it in that way require enforcement, or is it enough that it's just contained within the four corners of the lease?
No, it means, in this context, it means enforcement, because it's already in the first sentence, they talk about inclusion. In the first sentence, it says a lease that's included. So, all right, what happens if it's merely included? Well, it's unenforceable. As I said, it's not void. This lease can go on until somebody challenges the enforceability of a certain provision. Then you get to the second sentence, and it talks about use, and that was the fighting issue in the Staley versus Barkalow case. The Court of Appeals comes back and said, well, use means the same thing in that sentence that it meant in the first sentence. And we disagree with that. We think use has to mean you take the next step and you attempt to enforce it. And if you do so willfully, knowing that there's a prohibited provision, then you get your actual damages because you've enforced the agreement. And then the punitive, 2 months rent.
And can you get the punitives without, or are you entitled to recover attorney's fees or the multiple months rent if you don't have any actual damages?
No, we don't. Because we think that misreads, from a statutory interpretation standpoint, it just reads the terms and it says actual damages and punitive damages. It doesn't say or. As we point out in our brief, if you look at the Uniform Act, there are several provisions in the Uniform Act where they talk about actual damages or punitive damages, whichever is greater. And we don't have that in this statute. There's no way or is in this statute. And that's the problem we have with the Barkalow case, is the Court of Appeals did not even address the actual damage language. It just simply said, if a prohibited provision is included, then you go for punitive damages. Because it was the same thing in that case, there was no enforcement. They just skipped over actual damages. And what the plaintiffs have done in their brief, if you look at their brief in this case, they have also attempted to rewrite the statute. I think it's on page 15 of their brief, where they say if you willfully and knowingly include a provision, then the next step is to determine whether there are actual and or punitive damages.
Let's take a look briefly at the merits. I'm particularly interested in, please, in the liquidated damages. I'll call it a schedule, but there are a number of...
Right, that's right, Your Honor.
Yet your argument is basically that you have to have actual damages and so forth. And you've read the briefs, of course. The suggestion as well throughout the statute, we're talking about damages, and that a liquidated damages position is inconsistent with that. Please give us your best argument.
Well, our argument in counter to that is that the statute 562A.1 says unless specifically prohibited, the parties are free to include whatever terms and conditions they want to governing the rights and obligations of the parties. And the plaintiffs say, well, it talks about actual damages. The statute doesn't mention liquidated damages. So therefore, but my response to that is, well, if it doesn't say anything about liquidated damages, then it's not specifically prohibited. That's for sure. And so we think that these types of charges are the types of charges that are reasonable. Every landlord, has to encounter these problems. How are we? You have a $25 return check charge, And we're supposed to, I guess all the landlords then, if you want actual damages, you have to, how do you compute what the actual damages are for a return check charge? Is it, is it solely what the bank charges? What about your administrative time? And the other costs that go into determining what a return check charge is. And we just think these are the types of liquidated damage provisions that are not prohibited and that the parties still have some rights under Iowa contract law.
Maybe, and I do get your point, but I wonder about the what I call the anti-waiver provisions of the Act, which basically say that, I mean, in summary, that remedies are not to be waived under the statute.
Well, I agree, but I think if it said liquidated damages are not prohibited, then you couldn't impose them because you waive that provision. But it doesn't say that. All the plaintiffs do is they say, if you go through the statute, you can find 3 places or whatever where it says actual damages. Well, then you look further, and maybe there are 2 or 3 where the legislature just used the term damages. So 3 outweighs 2, so therefore everything in the statute should require actual damages, and we disagree with that, Your Honor. Thank you very much.
Thank you, counsel. Mr. Warnock.
May it please the court. I think that the appellant they really hit it on the head when they make the argument that there's no harm except from enforcement, and they focus entirely on enforcement. Let's look at, there's 2 sections that give the right to a legal lease. That's the key question here. As the Barclay Court said, do tenants have the right to a legal lease, a lease free from legal provisions? 562A11, the prohibited provisions clause, we've been focusing on that. 562A9, though, is key, and that says that a landlord and a tenant may include in a rental agreement terms and conditions not prohibited by this chapter or by law. That is a standalone requirement that you not put prohibited provisions in a lease.
All right, and a lot of what you're saying, I think I track. On page 66 of your brief, you say in a footnote that if the landlord wants to avoid liability for this 3 months of rent, it can either not use a lease that has the prohibited provisions, or it can disavow them. You remember that language?
Right, exactly.
Yeah. Where do you get this disavow notion
You get
from?
a landlord in Iowa City say, look, I just bought some property, and I'm looking at those leases. These leases look like they have illegal provisions. What should we do? And he said, you know what? Here's what I think we should do. I'm going to send a letter to them, to all the tenants, informing them that these questions have been raised about these provisions, and I'm going to make a promise not to enforce those provisions and never to use them again. And I said,
Where do you get that in the statute? I mean, it seems like good public policy, but where does that come from?
How else are we going to solve the problem? You can't unilaterally change the lease.
Doesn't the fact that there is a problem that would be difficult to solve because you can't unilaterally change a lease suggest that maybe your interpretation of the statute goes too far?
It's the problem with any time you have a statute as opposed to common law. When you try to figure out every possible thing that could happen with a statute, you can't figure out what the possibilities are. Now, it's clear, I mean, that's the beauty of common law. We can sit down and with a real case, with a real example, and work out a solution to it. That's what this court needs to do. And it's clear, to throw the baby out with the bathwater.
To work out real solutions, we have to interpret the laws as they're written.
That's how we do it. We need to look at a practical problem and say, what did the legislature intend? Are we going to throw the baby out with the bathwater and say there's no enforcement, that you can put illegal provisions in a lease? Because they do harm tenants. Let me give a real-life example. This court in DiStefano said no automatic carpet cleaning clauses. Now, there's 2 ways to put those in your lease. You can, one, like this landlord did, put a provision that says, well, we'll deduct it ourselves, we'll arrange for cleaning. The second method that Iowa landlords use is to say in the lease, you, tenant, arrange for cleaning, you pay for it. So under that scenario, the tenant looks at the lease, says, okay, I have to arrange for carpet cleaning. They pay for it, and the landlord has this windfall of carpet cleaning that they aren't entitled to from an illegal lease provision, and the landlord can say, hey, I didn't enforce it, not my
But that's
problem.
not this case, right? I mean, you're not claiming your proposed class representatives, your class reps, actually suffered actual
No.
damages.
But here's what that issue has not been decided yet. This is an interlocutory appeal. We're way early in the case. We had
Actual damages have your clients suffered, your named plaintiffs?
the actual damage that they have suffered is that they had illegal provisions put in their lease. And the legislature in passing this, if you look at the Uniform Act 1.403, the comments to that, which is analogous to our prohibited provisions clause, they point to the example of liability shifting clauses. And they say, look, these injure and prejudice tenants, even though they're unenforceable, because an uninformed tenant is not going to get their rights enforced. And they put, as a prophylactic measure, around illegal leases, they said you can't put illegal lease provisions in your leases. How else are we going to enforce it? Are we going to wait till there's damage and then say you have to take it out? I mean, it's like saying you can't have a 70-mile-an-hour speed limit. Hey, I can go 150 miles an hour. I haven't caused any damage. The legislature has said, look, you can't have illegal provisions in your lease. And that seems like a real basic, important point to have. I can't see why tenants think their lease is legal. They look at the lease, they believe it, they act on it. And for the landlord now, if the appellant is correct, then the landlord can put anything they want in their lease. They can put in a provision that says the tenant waives all the rights in the Landlord-Tenant Act. There's a $10,000 fine for late fees, and they can just say, hey, we didn't enforce it.
Counsel, I'd like to shift the conversation to a
Definitely.
different topic. Let's assume, just for the sake of our discussion, that this court were to conclude that the provisions of the lease that establish these fees are not illegal because the statute 562A doesn't limit damages to actual damages.
Right.
All right. My question then is, if this case were to be remanded, does the petition in this case present a claim in the alternative that the fees are unenforceable under common law principles having to do with liquidated damages? That is, that separate and apart from 562A, are they unenforceable under the common law because they're penalties and not proper liquidated damages? Did you allege that in your petition, and is that issue still in play?
I think that, that would be the normal course. I think that when you look at what potentially be liquidated damage, you go penalty. I think that's the immediate thought. What I realize with this is that we can cut to the chase. We can not only cut out liquidated damages, we can cut out fines and penalties. Because in many cases, that's what these liquidated damage provisions are, disguised penalties. I don't think that we allege that. I think our petition entirely focused on the Landlord-Tenant Act and also facial illegality. For example, we didn't raise unconscionability. All these issues are not raised.
Let me give you an example. There's a lockout, there's a fee for lockout service calls in the lease.
Right.
Is it your position that that's an illegal provision under the Landlord-Tenant Act?
I think what you
and
need
why?
to do is to charge your actual damages.
Wouldn't that be extremely impractical for a landlord to say, well, you woke me up in the middle of the night, that's to me, if I was a landlord, that would be worth a fair
I
amount
would
of
tell
money.
you this, it'd certainly be very, very easy for landlords to go ahead and just set the fees. Certainly it's convenient for the landlord. But there are many, I don't think this is not a commercial lease, this is not difficult. I mean, basically what you do is you say, well, you had to get up in the separate sections anyway. It's not that difficult. If I pay someone $20 an hour, it takes them a half an hour, that's $10. We're not dealing with rocket science here. These are whether you're going to clean the bathroom up and what it costs to fix a window. Those are not difficult things to figure. And the problem with liquidated damages is that too often they're disguised fines and penalties. And that's exactly what we see in this lease. If we look at the holdover provision, which says $300 a day plus damages, that's clearly a penalty. You can't get both of them.
You have a separate provision in the Landlord-Tenant Act that prohibits unconscionable provisions. Wouldn't that protect you against fees that are just excessive and out of the realm of reason?
Well, each of those is done on a case-by-case basis. Obviously, the Landlord-Tenant Act needs to be, the facial violations need to be taken care of first. And if it's for example, the holdover provision that they have, it's $300 a day plus actual damages. That violates 562A34.4, which only permits actual damages for holdover. So right there, that's an illegal provision in and of itself. So they're knocked out on that one. We're gonna have to the courts are gonna have to go through on a case-by-case basis, look at where that's damages or actual damages, and then figure out, okay, is it a penalty every single time? And under the Landlord-Tenant Act, the landlord has the burden of proof of proving their case with security deposit deductions. Yet with liquidated damages, whoever's challenging it has the burden of proof. How are we gonna reconcile that? Actual damages, you can never complain that you get actual damages that you've been treated unfairly. Liquidated damages, somebody's getting overcharged, somebody's getting undercharged. And the landlords always set these fees. The leases are drafted by the landlord, and they set that fee high enough that they always make a profit. And in addition, they get the penalty, the advantage of having a penalty. That's what I've talked to landlords, they say, we have to have these penalties. How else can we coerce tenants? Nobody gets to do penalties. For some reason, they're off in this other realm where they have to have the right to penalize their tenants. And we can see that example in this lease. So that's the problem. And again, this thing, oh, we added up the numbers. No, look at how the interaction between liquidated and actual damages. If you look at, for example, 562A14, which is the landlord's right to possession, it says the landlord, if he's kept out of possession, can get an action for possession and damages under 562A34.4. We go to 562A34.4, that's a holdover provision, it says you get actual damages. As you move back and forth between the use of damages and actual damages, you can see they're synonymous, and we've given a number of examples of that in the Landlord-Tenant Act. Actual damages are fair, they're easy to figure out, they're easy to come up with, and nobody can complain that they're not getting a fair deal with actual damages. Liquidated damages all too often are nothing
Counsel,
more than
excuse me,
penalties.
could you address the defendant's argument that you're effectively rewriting section 562A11 to change an and to an or? A tenant may recover actual damages sustained by the tenant and not more than 3 months periodic rent and reasonable attorney's fees. How do you get reasonable attorney's fees and 3 months rent without actual damages?
First of all, it is possible to have actual damages without enforcement. And I gave that example where the lease provision wasn't enforced, but nevertheless, it's in the lease. To say that we're writing a lease and that has no effect whatsoever, that does affect tenants' behavior. They can suffer actual damages.
But that would be a
from that.
case-by-case basis. I mean, you know, I know you argue that if you have unlawful provisions in a lease, that can or might affect the relationship, or it might not. It might not. Ordinarily, for actual damages, we need more than speculation. I mean,
I'm actually not obsessed with damages. I mean, when we did these cases, the purpose of the class action was to be able to look at leases and clean them up. 562A9, as I look at that provision, it says you can't put illegal provisions in a lease. What's the relief? Under 562A4, you have a right to action. You take them out. And if we were allowed to go into court, get a declaratory judgment, whether it's valid or not, and then get them to take those lease provisions out, I would be about 75 or 80% satisfied. If the tenants actually then had actual damages, they should pay them back. For example, in this case, they have automatic carpet cleaning.
as Mr. Holtman points out, your current clients are not renters any longer,
Right.
if I understand it.
Right.
So,
It's capable of repetition yet evading review. You're dealing with a situation where you have thousands of tenants have these provisions in their leases, but only for a year. There's no way I'm going to be able to go into court, get a ruling from the district court, and then get a ruling on appeal within a year. Yet these
were they
issues
tenants to
happen
start with and then aged out?
Yeah, basically, we ran the clock out.
Oh, when
This
you
is-
filed the claim.
No, I think actually that before this, I think that's the point with that would be that's kind of at the margin of that, because yeah, these are before we did file the case after their lease had lapsed. So yeah, we need to show damage. The damage is that they had illegal provisions. The legislature in passing
Is that
this-
damage? I mean.
Yes, it is. It's every illegal
How many
provision.
dollars? I mean, ordinarily damages, we put a dollar value on and we can see the injury and so forth. I mean, I do understand the argument that by putting illegal provisions into a lease, it could have an interim effect, and it might, but ordinarily that's subject to individual proof.
Let me give you another
And-
example that's not, I think the focus here is 100% on financial damage, whereas, again, let's look at other type of damage in the Landlord-Tenant Act. A9 governs access. And we have a problem in Iowa City with middle-aged landlords busting in on their young female tenants. So if that happens and they violated the A9, what's the monetary damage? She was in the shower, he busted in, she's not out any money.
Well,
Yet
it'd be
that's a right.
emotional distress damage, I would think.
Right. What's the damage of being misled by your landlord? What's, you look at the lease and it says, okay.
But you have to have testimony. Don't you ordinarily have to have testimony? Somebody comes in and, like in the landlord-tenant midnight busts in or whatever. So the tenant says, I was in the shower, it was 12 o'clock at night, and can you imagine the horror of this? I heard sounds, I heard the breaking of the door, I heard this, that, the other thing. I'm in the shower, I felt invaded, so forth. I mean, some jury, if under those facts, may well give some substantial emotional stress damages.
Right.
But to simply say, I rented in the past, and there were some illegal provisions in the lease, I might not have been aware they were illegal, didn't really rub me because we didn't have a dispute over them, but I've been injured by them. I mean, I'm just, in the sense of actual damage, I guess I have a problem.
Going to the access, you can get injunctive relief and actual damages. So my view would be that, hey, if someone keeps coming into my unit, I can get an injunction against that. Again, the key is, how are we going to vindicate the right to a legal lease, or do they not have it actually? That in fact, you only have the right to have it, even though the legislature says you may not include these provisions in the lease if it's prohibited. No, we're going to read that out because in fact it has to be enforced, and until it's enforced.
Take a current tenant, maybe a current tenant has to bring a declaratory action.
Your Honor, I'd be perfectly happy with that. If the court comes back,
that's not this case.
Well,
right?
then we under Hammer v. Brandstadt, we have an opportunity to come back and there's a class of people out there. There's many potential tenants. If we've screwed up, if we've made a mistake in terms of these particular class representatives, send it back. We are entitled to a reasonable opportunity to find new class representatives. Even if we don't, these issues that we've raised are in thousands of leases. It's capable repetition yet evading review. We have landlords and tenants waiting to find out, can we have liquidated damages? Can we have these liability shifting clauses? What are the rules? Give us some guidance. And I apologize, I can't solicit clients. I don't gin up these cases. People come to me and I have to work with what I've got. It's not like a huge organization. It's myself and Ms. Boyer. We're not making huge amounts of money on it. It wasn't done in some way to kind of stir up trouble. We're very happy. In fact, with this landlord, we sent them a letter. We said, look, we have problems with your lease. Would you sit down with us? If they clean up the leases, that's the end of it. We're not interested in getting huge damages. If we have to, we'll go forward. If it's necessary for standing, okay, fine. But our main focus is cleaning up leases and getting guidance from this court. So I appreciate the opportunity, and I'm hoping this court will go ahead and reach the substantive issues that we raised today. And please, let us get declaratory judgments. Let us clean up the leases, and if we can't get damages, so be it. Thank you, Your Honor.
Thank you as well, Counsel. Mr. Holtman, you may present your rebuttal.
Thank you, Mr. Chief Justice. The problem we have here is I have a client who has probably 14,000 some odd tenants. And if this state Barcalow provision holds, and all that he has to do to violate this statute is to put in one provision which is prohibited, which has never been enforced against anybody.
But that's more than that. He has to know it was a wrongful clause when he put in the lease. And that's a different angle of this thing. And some of these provisions, if you read our Di Stefano or Caruso cases, you may not get there.
Well, but that's a risk. That's a risk that a lot of clients, Your Honor, will simply not want to take. To go to a jury and have a jury determine whether or not a $30 million judgment is going to be awarded against this client based upon a jury's finding of willfulness. 14,000 tenants times 3 months' rent, let's assume the rent is $1,000 a month, that's 14,000 times $3,000. And that's the problem that you have.
But that's the cost of doing business when you put in provisions that you know shouldn't be there. I mean, that's it. What if you put in a provision in the lease you can't have African Americans in the house? I mean, you just can't do some things, and if you do some things, you need to pay whatever the legislature says you're responsible for.
Well, you have to have, the legislature says you have to have actual damages. And I want to focus on these named plaintiffs in this case. That's the case that we have in front of us. It's not some, Mr. Warnock wants you to just simply broaden this out, and as we've emphasized over and over again, come in under the guise of a standing, plaintiffs withstanding, and just give an advisory opinion. The discussion about what's wrong with having a prohibited provision in a lease and stopping there without any enforcement, that whole discussion comes from the Wisconsin case that our Court of Appeals relied upon. And you need to go behind that Wisconsin case and see what's going on in that case. Because Wisconsin, number one, doesn't have the Uniform Act. It didn't enact the Uniform Act. It did this under the standards of a uniform business practices, prohibited business practices. It's a Federal Trade Commission Section 5 clone is what that act is. And the Attorney General is the one who's charged with enforcing that. And all of the testimony that our Court of Appeals relied upon about, well, people, you put this in and they're unsophisticated and they don't know what this is about and they're not going to rely upon it, all that was done in the context of whether or not Wisconsin should say this is an unfair business practice. And if you look at that, in that case, that was an individual who was the party up in that Wisconsin case who was taking advantage of this. And the Wisconsin Act specifically says if you're going to have a private attorney general type provision, you have to have pecuniary monetary damages. You can't just simply come in like the Attorney General can. The Attorney General can come in and say, this is bad policy to have a prohibited provision in any lease. And we declare that to be an unfair business practice, and we're going to enjoin it and prohibit it. That's fine. We could do that in Iowa, too. But if it's an individual plaintiff, like we're talking about here, the statute specifically provides that you have to have
But if we
actual
read the
damages.
statute differently than you, we are finding the legislature allowed these people to bring this cause of action, different from Wisconsin.
No, because they have to have actual damages. I mean, I think Justice Apple asked the question of Mr. Warnock about, well, what are your actual damages? And he said our actual damages are having prohibited provisions in a lease. And I'll submit to you that that is not the way this court has interpreted actual damages and should not be the way. I mean, they're compensatory. They're compensatory damages. You have to, without that, you cannot proceed further. And that's the way the Iowa legislature, as I indicated before, under the Uniform Act, there were some provisions where you could use or. Actual damages or punitive damages, whichever is greater. Well, you have no actual damages if there's been no enforcement.
Why can't it be actual damages, comma, if any, and liquidated damages? It doesn't say if any.
It doesn't say that.
I know it, but it also doesn't say what you're citing in the other statute, whichever is greater. We don't see that.
Well, no. I mean, I'm just trying to do statutory interpretation, which I think you come to the same result whether you use the plain meaning of the words or whether you engage in it's ambiguous and you go through all of the analyses that you go through with an
The
ambiguous
legislature,
term.
arguably, let me just try a theory on it and give you a rebuttal, but the legislature decided not to establish some kind of administrative agency to supervise, kind of these contractual relationships, but instead had kind of a provision where tenants act as kind of private attorney generals to make sure that unlawful provisions aren't in the lease, and if they have a lease that has unlawful provisions, they're entitled to, among other things, liquidated damages.
No?
I mean, why shouldn't we read the statute that way?
Well, Because I mean, it just doesn't, it just doesn't say that. I mean, I don't know what else to say other than it says what it says, and it's, as I indicated at the outset, the whole structure of this is enforcement. It's an enforcement. It's not the private attorney general view up at 30,000 feet where the attorney general looks after everybody and what's good public policy and not. The only private attorney general statute that I'm aware of that we have in Iowa is the consumer fraud statute, where the legislature, granted a private right of action under 714H. But even in that, it said that I have it, you can, a consumer who suffers an ascertainable loss of money or property as a result of prohibited practice or acts in violation of this chapter.
I guess my only point is that you could regulate content of leases in a regulatory way with the government bureaucracy.
Yeah.
Or you could arguably establish a private cause of action
Yeah,
to do
you
the
could. I
same.
don't
And, I agree with you that we gotta look at the four corners of the statute, and we gotta look at the specific wording. But I guess I pose, I'm not sure that the statute wouldn't support the notion that a private party can seek liquidated damages where a landlord uses an unlawful provision. I mean, that's what we're struggling with.
Well, and I just come back and say it said actual damages. It doesn't say. I mean,
You say actual damages is required, and don't go past go, you're done.
I mean, you could have statutory damages in the sense where the actual damages are difficult to compute. So the statute could have said, if you do all this, you're entitled to $1,000, just as a statutory damage. And if you do so willfully, then you get three times that or whatever. I agree with that, but that's not what we have here.
Thank you,
Thank
counsel. The case is submitted. The bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.